So today's session is Law for Accounting. My name is Shazia Khan, and we're doing Learning Outcome 4 today, which is to understand areas of law affecting business and professional operations. And this is the last learning outcome before we do the assignment discussion. So just a summary of what we did in the last session was we looked at the legal principles, legislation, case law and ethical codes. We identified the law and regulation and guidance. We looked at the ethical, we looked at constitutes money laundering. We looked at money laundering, fraud. We looked at bribery, and we looked at the national and international regulations. We also looked at the formalities for analyzing the relationship between legal principles, case law, and ethical codes. We looked at what money laundering was, the law around money laundering, ethics and ethical behavior. We also looked at the ethical principles, which were integrity, objectivity, professional competence and due care, confidentiality and professional behavior. We looked at why it's important to comply with law. So we looked at criminal law and civil law. And we looked at the accountancy profession in regards to the organisations, which is IFAC, the Consultative Committee, which is CCAB, HMRC, and the National Crime Agency. And we also gave examples within ourselves of different issues around crime that have happened within our profession. So we've looked at that and the importance of that within a profession. I think maybe Irene Muqsood. Right, so today we'll be looking at Learning Outcome 4, which is to understand areas of law affecting business and professional operations. And this is the last learning outcome before we do the assignment. So Learning Outcome 4, assessment criteria. 4.1, to analyse the requirements of data protection legislation. 4.2, to explain how intellectual property can be protected. 4.3, assess the impact of legislation relating to employment. And 4M1, to assess the importance of intellectual property rights to businesses. Indicative content. So we looked at data protection. We're going to be looking at data protection legislation. So the use of information in a business. Requirements of data protection legislation. So Data Protection Act 2018. GDPR. The impact of requirements on business. Penalties for non-compliance. Why that's so important. Intellectual property. So the different types of intellectual property. Protection through copyright, patents and trademarks, protection of digital assets, remedies for unlawful use of intellectual property, importance of intellectual property for business. And then we're going to go on to employment law, so employed and non-employed status, legal consequences of employment, key features of employment contracts, termination of employment contracts, unfair, wrongful and constructive dismissal, statutory redundancy, employer obligations, and equal opportunities legislation. So what is data protection? Why do we need data protection? So key pieces of information that are commonly stored by businesses, be that employee records, customer details, loyalty schemes, transactions or data collection needs to be protected. This is to prevent that data from being misused by third parties for fraud, use of hazing, scams and identity theft. There are 3 requirements of Data Protection Act, and there's 6 important Act principles. So to be obtained and processed fairly, lawfully and transparently, to be processed for specified explicit and lawful purposes and shall not be processed in any manner incompatible with these purposes, be adequate, relevant and not excessive for these purposes, be accurate and kept up to date, be kept for no longer than necessary for the specified purpose, and be processed in a secure manner. So when we talk about being processed for no longer than necessary manner, now within the law firm, I'll tell you, law firms are only allowed to keep files for up to 6 years. I'm not sure with the accountancy side, do you have a limit on how long you keep files for?
7 years for tax reasons.
7 years. Right, okay. And that's customer files, yeah?
I think your corporate files, which obviously includes every detail.
Sorry, I can't
Yeah.
hear.
I'm saying
Who's speaking?
it's Najim.
Oh, hi, Najim, yeah.
Yeah, it's all the files that makes up your numbers, meaning
Okay.
customer, supplier, everything.
Okay, so yeah. So within law, you only keep them for 6 years, and then within accountancy, it's 7 years. So, and is there a need to keep them that long?
Yes, well, because it's required by the law.
Yeah, it's a requirement. And obviously a lot of institutions now don't just keep, hard copies, they tend to keep them on the computers online as well,
Yep.
which can be
Cloud-based.
destroyed then as well.
Mhm.
So what is intellectual property? Intellectual property is something that you can create using your mind. For example, a story, an invention, an artistic work, or a symbol. So what intellectual property is? Having the right of a type of intellectual property, that protection that helps you stop people stealing or copying. The names of your products or brands. So could an intellectual property be Coca-Cola?
Yes, it is.
Yeah. Your inventions, the design or the look of your products, things you write, make, or produce. Copyright, patents, designs, and trademarks are all types of intellectual property protection. Now, when we talk about intellectual property, is there a lot of fraud within intellectual property?
Yes, it is.
Why does it occur?
Well, somebody could,
And
well,
do you know any
to take,
examples?
yeah, meaning to take advantage, meaning somebody could copy somebody else's name, for example, and sell the product, like counterfeit product.
Yeah, I remember years ago there was some young boys from the West Yorkshire area that designed a drink in Dubai. I don't know if you heard about it. It was called Duracell or something.
Okay.
An energy
Right.
an energy drink.
Right. So exactly. So you can't it's a use of somebody else's name in
Yeah,
movies, for example, copying somebody else's voice, for
yeah,
example. That's IP.
yeah. I think that would at the moment with AI, I think that will be the thing that's going on quite a lot, copying
Yep.
someone's voice. Yeah, so copyright could be the fact that, if and sort of patents on it, and they got actually sued for that. They actually got sued because they took the drink to Dubai and thought, oh, it's in Dubai and it'll be acceptable, but it wasn't. It was, I think the drink was called Duracell. I'm sure it was.
Very creative
So
name.
we've got employment law. Sorry?
Very creative.
What was that, Najam?
I'm saying it's very creative.
Very creative. Pick up a box of batteries and that's your
Yep.
imagination. What is employment law? So employment law groups together all laws, regulations. It regulates many aspects of our working life, things like working time, minimum wage, health and safety, childcare, equality is a big one, trade unions, pensions, contracts of employment, dismissal, redundancy. And within that diagram, it shows you employment rights, leaving employment, anti-discrimination laws. Give me an example of discrimination within the workplace. What could it be? What kind of forms of discrimination do we have?
Well, this again quite famous, right? Promotion of men versus women in the workforce.
Yeah, women, gender. Gender's a
Yep.
big one.
Yep.
What else?
Disability is another one, right? Meaning it could be.
Disability is a big one because what's happening is a lot of people are sued under the Disability Discrimination Act because of, discriminating against anyone that's got a disability or is in a wheelchair, anything like that.
Yeah. Yeah.
What other things? Because you have the protected
faith, meaning
characteristics.
religion, exactly, religion, faith,
Yeah.
ethnic minorities.
Age is a big one.
Yeah.
Where, someone is not employed because of their age.
Yeah.
And I'm glad they've brought in a law in regards to that, as a protected characteristic, because people do, and I will say this within the law profession, if you go in as a 25-year-old young person trying to get a training contract and you go in at someone who's 45, it's more likely the 25-year-old will get that. So a lot of people, when they study law, they think, is it the right time for us to study because the profession will discriminate? And it does happen. It does happen. And, you know, again, gender, being a woman, you know, that's another thing that's, you know, an issue. Whether there's that glass ceiling of women being paid less again than men.
Yeah.
And doing the same job.
Yeah.
I don't know if it is the women on. Irene's on, and Violetta
Yes, I
on.
am.
What do you think about that? Hi, Irene and Violetta. What do you think
Hello.
about that glass ceiling for women and men?
Excuse me?
I think that there is a bit of glass ceiling for women because
Yeah.
women are kind of discriminated against, particularly because by the time they are having family, they tend to take more time. So there's that glass ceiling, you know, somehow for women.
Yeah. I think there's
and the pay and the pay as well, you know.
yeah.
Men generally are quick and are open to negotiate their salaries and ask for more. Unlike women, you know, when for men and women doing the same sort of job, the woman might not ask, and even if she asks, she might not be given that much attention as a man would, because they look at the man as having more responsibilities. He's got a family, he's got children, but they don't look at women like that. So there's definitely a glass ceiling for women.
Yeah, I think we've got about 3 men on here. I don't know what they feel.
I'm a 21st century man.
What's that, Hanish?
I'm a 21st century man. I believe in.
So you're one of the good ones, are you?
I've been well trained by.
Yeah. There's not many of them around because, you know, in the profession, any profession, I personally think there's still that you know, that, like Irene said, there's still that glass ceiling where women are doing the same job but paying less, because typically the job of a woman, they say, is to stay at home. I mean, I don't mind that, but you know, it doesn't happen all the time. But so we've got 4.1, which is to analyze the requirements of data protection legislation. Now, under section 6, section 6, subsection 1 is the consent of the data subject. Under section B is processing is necessary for the performance of a contract. Under section 6.1c is processing necessary for compliance with legal obligation. 6.1d is processing necessary to protect the vital interests of a data subject or another person. 6.1e is processing is necessary for the performance of a task carried out in public interest. Or 6.1f necessary for the purposes of legitimate interest pursued by the controller or third party. Personal data. So if someone asks you what your personal data is, without reading this definition, what would you say your personal data is?
Your name is your personal data, national insurance number, your
name, your national insurance.
Yeah.
What else?
Ethnic background, your.
Could it be your phone number, your address?
Well, yeah, address, exactly.
I think all the information which belongs to this individual, is
personally theirs, yeah.
Mm-hmm.
So personal data is defined as any information about a living individual which is capable of identifying that individual. Sensitive personal information is divided as any information relating to an individual's racial, ethnic, political opinions, religious beliefs, their sexuality, their health conditions, physical or mental, criminal activity and criminal record. And I think within that it'll be on your special categories of personal data. So that would be, if you were to do a DBS, that would identify all your data.
Mm-hmm.
What is data protection? Data protection is about avoiding harm to individuals by misusing or mismanaging their personal data. So if you collect, use or store personal data, then the Data Protection Act applies to you. It sets out 8 principles you have to adhere to, which include, these are a couple of them: only collect information for specific purposes and don't use it for other purposes. Only collect what you need for specific purposes. Keep it accurate and up to date, safe and secure, and process information lawfully and allow subject access in line with the Act. GDPR. Why do you think there was a need in 2018 to introduce the GDPR regulations?
For the very reason to protect the vulnerable, to protect the data from moving, meaning moving around.
Yeah.
And getting
But
lost and
also
all kind of
is,
cybersecurity issues and stuff like that were kind of,
Yeah.
people were getting.
But
So,
if we look at it today, Najam, do you think, oh, sorry, was it Hanish? Was it Hanish or
Najam.
Najam? Najam, do you think even looking at data protection today, do you think we are fully protected
no,
as a
no,
society?
we haven't. No,
No,
we
we
haven't,
haven't, no.
because firstly, GDPR, again, there are different variations. It's a globalization, right? So GDPR, there are local set of rules in countries. Sometimes you could be buying something from another country where there is no GDPR.
Yeah.
So there still are variations. So we are not fully
Still not
protected.
protected.
Yeah. The other thing is with the use of internet and the e-commerce, right? Meaning your data could be secured in a country that is not under GDPR versus, you as a customer in a country where GDPR is applicable. So again, it is not, smaller organization cannot cope up with that compliance requirements or even understand it.
I've always kind of been a bit dubious to that, because I've never thought anything would happen if it was on the internet. I've had times where I've paid for stuff and never received the stuff and registered my card online. And I don't know if that's safe or not, but I've always kind of not thought of anything, but I've had incidents historically where, I've had to change my card so many times because fraud was done whilst I registered my card online.
Yep. Exactly.
So,
Obviously, there is a SSI and secure protocols, but still, it's not safe. If it's not with you, it's not safe.
It's quite scary, isn't it? That we're still not protected. So the key changes in the Data Protection Act was try and strengthen rights of individuals and place more obligations on organisation in regards to looking after personal data. But it's not always the case now as well. In order to comply with the law, you must have a legitimate reason for processing that data. You must have consent, must be freely and unambiguously given. Data processing activities must start with privacy by design and default. Subject access requests will include how you process and share data, and subjects can request data deletion. There will be mandatory breaching reporting. Data processors will be held liable. You must be able to demonstrate compliance with GDPR, and while the ICO say it's the last resort, the potential fines must be greater than at present, so up to 4% of annual global turnover of 20 million. GDPR principles: lawfulness, fairness and transparency, which we went through earlier, purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, and accountability. Data protection terminology: the data controller is the person or organization who determines how and what data is being processed. The data subject is the person about whom personal data is being processed. A data processor is the person or organization who takes an action with the personal data you control. This might be a third party acting on your behalf. Processing is anything done to personal data, including storing it. And the data protection officer, DPO, is a specific role will be a legal requirement for many organizations, including large church bodies such as NCIs or dioceses. I remember years ago there was I don't know if you remember, there was a scandal, and it was one of the I can't remember, one MP, and he'd lost the child benefit CD with all the details of everyone's on. So the child benefit CD went in the post from it was from HMRC, I think, and they'd lost the child benefit details, the CD, and it had everyone's details on it, and then details were being sold on eBay, national insurance numbers, the person's details, date of birth, things like that, and it was quite a big scandal at one time. So, anyone's data is really important. It shouldn't be really shared. GDPR are all about making sure data processing and sharing is done properly. They're there to prevent legitimate data sharing. So there's a lot you can do without consent. For example, you can process personal data without concern where it is for the performance of a contract, for compliance with the legal obligation, to protect the vital interests of data subject or another person, to exercise of official authority or in the public interest, and the purposes of legitimate interest you are undertaking. Only if none of the above apply do you need consent. 4.2. Explain how intellectual property can be protected. Intellectual property is protected by law, for example, patents, copyrights, and trademarks, which enable people to earn recognition or financial benefit from what they invent or create. Protecting your intellectual property makes it easier to take legal action against anyone who steals it. So types of protection, automatic protection, which is copyright and design right, so writing and literary works, art, photography, films, TV, music, web content, and sound recordings, that's copyright. Design right is shapes of objects. Protection you have to apply for. So these are ones that you would have to apply for. Type of protection, the trademarks. So that could be a product name, a logo, or a jingle, and time to allow for your application is 4 months. Registered design could be appearance of a product, including a shape, packaging, pattern, colors, decoration, 1 month, and patents, inventions and products, machines and machine parts, tools, medicine, around 5 years. Why is it so important to protect your intellectual property?
Well, to make
To
sure
prevent copyright.
it's not illegally used, or
Sorry, what was that?
so it's not illegally used, number one. Number two, to kind of to deter somebody else, taking benefit of, meaning you losing turnover if somebody else is copying your logo and selling stuff. Could be fraudulent, could be
Is
helping safety.
is
Somebody.
copyright and patent the trade? Is it quite a growing concern?
Big time.
Yeah. Violeta, what were you going to say?
Well, I lost my idea already. I've listened to, yeah, sorry, just continue.
All right, okay. Maksud, I think we've got Maksud on as well. Can you hear?
Sorry, yeah, my line was muted. No, yeah, copyright is a going concern,
Yeah.
definitely. What I would say, like, there is a two risk of if you start something on your own, whether it's a trademark or whatever it is, the first thing is, like, if you don't copyright it, so down the line somebody might copyright that name, and then you'd be in risk not to use your own trademark. So that is one side. The other side is you might be, if you don't try to copyright it, that means you haven't done your background check whether this title has already been copyrighted by somebody else. So you might be in risk to using somebody else's, like, registered trade name or something like that, which is already copyright. So that there are like
you need to protect it.
Yeah.
You need to protect your work.
And that's it. Yeah.
Yeah, copyright protects your work and stops others from using it without your permission. You get copyright protection automatically. You don't have to apply for it. You automatically get copyright protection when you create original literary, dramatic, musical, and artistic work, including illustration and photography, original, non-literally written works such as software, web content, and databases, sound and music recordings, film and television recordings, broadcasts, the layout of published writing, written, dramatic, or musical works. You can mark your work with a copyright symbol, your name, and the year of the creation. Whether you mark the creation of work or not, it doesn't affect the level of protection you have. How copyright protects you? Copyright prevents people from copying your work, distributing copies of it, whether free or charge or for sale, renting or lending copies of your work, performing, showing, or playing your work in the public, making an adaptation of your work, putting it on the internet. Copyright overseas. Your work will be protected by copyright in other countries through international agreements. For example, the Berne Convention. In most countries, copyright lasts a minimum of life plus 50 years for the most types of written, dramatic, and artistic works, and at least 25 years for photographs. It can be different for other types of work. How long does copyright last? Copyright protection starts as soon as the work is created. Once your copyright has expired, anyone can use or copy your work. The length of copyright depends on the type of work. So if you've got written, dramatic, musical and artistic work, it usually lasts 70 years after the author's death. Sound and music recordings, 70 years when it's first published. Films, 70 years after the death of the director, screenplay, author and composer. Broadcasting, 50 years from when it's first broadcasted. The layout of published editions is 25 years when it's first published. Patenting your invention. You can use a patent to protect your invention. It gives you the right to take legal action against anyone who makes, uses, sells or imports it without your permission. To be granted a patent, your invention must be of the following: something that can be made or used, something that's new and inventive, not just a simple modification to something that already exists. Patents are expensive and difficult to get. Can anyone give me an example of a patent?
Mona Lisa.
Mona Lisa, yeah. Anything else? What could be an invention?
Well, it could be a piece of software, for example, in animation industry. So you could get patents for so nobody else can use it. It's like a character, for example, like a character in play. That's a patent. You can apply for that. Scientific and invention, you can get the patents like cancer drugs and stuff like that.
Yeah, excellent. So what could not be patented? So that could be types of work that could not be patented is literally, dramatic, musical or artistic, a way of doing business, playing a game or thinking, a method of medical treatment or diagnosis, a discovery, scientific theory or mathematical method, the way information is presented, some computer programs or mobile apps, essentially biological processes like crossbreeding plants and plant or animal varieties, protection of digital assets. So what are digital assets? Digital asset is a digital entity owned by an individual or a company. And examples include digital photos, videos, and songs. These are assets not tangible, meaning they have no physical presence. Instead, they're files that reside on a storage device, such as a local computer or a cloud-based storage network. Protect important digital assets as intellectual property. So implement 2FA wherever possible, manage rights and access, and follow Wi-Fi security best practices and get the right insurance in regards to that. Remedies for unlawful use of intellectual properties. So there are remedies available for successful payments in a private civil infringement action, things such as compensation, which is an award of costs, an injunction, damages or an account of profits, delivery up or destruction, tracing orders, or orders for the publication of a judgment. There are three kinds of remedies against infringement of copyright, namely civil remedies, which is again injunctions or account of profit, criminal remedies, imprisonment of the accused or imposition of a fine or both, and administrative remedies. Some relevant questions. So why should I protect my intellectual property? And carrying out an intellectual audit. Why do you think it's important to protect your intellectual property?
Could be many reasons, including monetary.
Yeah. What about trying to protect your invention as well? If you're a business, why do you think it's so important?
Well, then that we could maybe prove that that was invented by us as well. It's like our rights as well, which is quite important at this stage.
Yeah, because no one else could take it then, could they? Or use it.
And then that theirs rather than ours.
Yeah. Why is it important to carry out intellectual property audits?
Maybe in case of as well, I don't know, maybe in case if someone is coming to check you, so you could prove it that you have protected it. That's another thing. I don't know if that's...
Yeah, and also it identifies where intellectual property property is used within your organization. So who currently owns it, who has the value of it. So you need to arrange protection around it.
Yeah, like insurance policy, you need to understand what it is,
Yeah.
identify it, value
Yeah.
it before you protect it.
Yeah. Importance of intellectual property for businesses. So patents protecting inventions. Inventions are protected exclusively by patents and are granted for a set time of period from Intellectual Property Office. Patents are granted for inventions that are not currently under patent in any way. Conduct a patent search to find out if someone's got there before you have. Once your invention has been patented, it is relatively easy to litigate against a third party that you feel is unfairly using your intellectual property. Trademarks protecting concepts and ideas. Trademarks cover the unique, distinctive way you represented certain aspects of your business, such as slogans and brand names. In theory, legal action can be taken without applying for a trademark, but the disputed asset has been used to build sufficient trading reputation and goodwill. Design right and registered design. So the three-dimensional objects. Design right provides automatic protection for the appearance of three-dimensional objects. This protection is limited. Registering the design widens the degree of protection and extends it to two-dimensional objects. Importance of intellectual property for business. We've got copyrights. Copyright protection is automatic in the UK, but not in the US, and does not need to be applied for. It is given all original literary or artistic creations that are a result of intellectual effort, skill, or creative powers. This would include website content, instruction manuals, and painting, as well as sound recordings and software. Protecting your rights overseas. Intellectual protection is territorial. It is only applicable to a specified region or country. So many countries have similar laws to the UK. So they have similar laws to protect their own things in each country. So they have their own laws. 4.3, assess the impact of legislation related to employment. Employment law regulates the relationship between an employee and an employer. It governs what employees can expect from their employees and what employers can expect from their employees and the rights at work. Employment law covers legal requirements, checks and processes in recruitment, your terms of contract on your employment contract, data protection, holidays, working hours, pay, health and safety, maternity, parental rights, discrimination, whistleblowing, employment tribunals. Why do you think it's so important to protect, when you talk about employment law, to protect your data?
In case something is happening that, I don't know, we could prove that we had agreement and he knew what he's going for, and he is the one who is actually has this and that name, date of birth, this and that, in case of, big scandal, that he wouldn't say, oh, this is not me, that's not my name, or my date of birth is not this or that. So there are many aspects of that.
Yeah, if you protect your employment rights, it prevents you from going to a tribunal or taking your employer to a tribunal if they follow the requirements. For example, if you've got health conditions, should that be in your employment contract?
Of course, because otherwise you would hide something what your employer didn't know, and maybe that could prevent of few things.
It's like disability. If you have a disability, you should inform your employer of this so they don't breach the law in regard to disability.
I think there's I think I've read recently somewhere that when you apply for a certain position, you have to be honest, otherwise you are obviously breaching the law if you are hiding this or that. So that would be a breach of law as well from the employee side.
Yeah, because that contract, would that contract be void?
Obviously, it might be. So who knows? Maybe the person would, ignore this information, and you would say, you know what, you'll make it. So
you need to be very clear on what you say, when what you need to open up and tell them everything about if there's any sort of illness.
Yeah.
or anything like that, because they need to cater for you. So employment and the law, we have health and safety legislation, anti-discrimination laws, and employment rights and leaving employment. Type of employment there are two types of working relationship. Employee works under contract of service, and a self-employed works under contract for services. So one's of services, the other is for services. The Employment Rights Act 1996 gives employees certain rights, such as right not to be unfairly dismissed, a right to redundancy payment if made redundant, and a right to minimum period of time notice to terminate the contract. The Equal Pay Act 1970 deals with not only pay but other terms, holiday and sick pay, implies an equality clause into all contracts of employment if workers are of the opposite sex, do the same job or different job of equal value. The working time regulations, these looks at the limit of hours of work, an average of 48 hours a week. Also gives the right to 4 weeks paid leave a year and 1 day off each week. The Employment Act 2002 gives parents or children under 17 or disabled children under 18 the right to request flexible working arrangements. Do you think there's an increase in flexible working arrangements now?
Yes, exponential increase.
Yes. Why do you think there's an increase in that?
I think one is awareness. I mean, COVID obviously kind of made it more obvious that, people can, and organizations had no choice but to give. Now, the more I interview people, for example, they always think it's their right rather than a privilege. Which is something I interviewed somebody.
I've heard that before as well.
It was like she was almost like demanding that she only wants to travel twice a week, and so like I cannot write in an employment contract.
I've heard that, where
like so it's a privilege.
I work with an organization that deals with domestic violence, and when I interview people, they predominantly say that flexible working hours is a right.
Rather than privilege. So again, it's he and she, meaning I didn't want to kind of, gender, it's not a gender bias, it was a person. But again, it is becoming, so whilst it is good, it obviously has its own downsides, right? American banks are pushing for people to come back. So the camaraderie and various other things.
After COVID, there's a lot of things like hybrid and remote working as well. So a lot of people have got used to the idea of sitting at home and doing it. And to be honest, I wanted to go out and see faces, but I don't think people want to do that. Some people just want to stay home and work from that.
Yeah, I don't know if you read that there are some local government or local councils within the UK. They did this pilot program of 4 days a week. And they kind of implemented it, and the UK government has recently kind of thrown them under the bus.
I read an article a while ago about that they're doing 4 day a week.
Yes,
I don't mind
that. I think last week government threw them under the bus and said anybody who has made this compulsory has to reverse it or we'll take action.
But I also think that, and I read somewhere a couple of days ago that our Prime Minister Rishi Sunak is planning to get rid of all the bank holidays.
Well, okay.
Starting from next year,
Yeah. Our American friends think that we have got too many bank holidays anyways. I can tell you that.
He's trying to get rid of them because he said that, people need to go back to normality and, try to help more businesses out there. Oh, God. The national minimum wage imposes minimum levels of wage and, what the requirement is for different ages. So the national minimum wage in 1998 creates a minimum wage. 2021, 891, and it's gone up now for people aged 23 and over. 836, this is quite old, 2021, 21 to 22. I think it's gone up to £12 and £10. Why do you think, when we look at the national minimum wage, why do you think there was a need to do this?
I think one is inflationary pressure, meaning I think the overall cost of living is high. So that's, to make people ends meet, really. That's what that is, minimum. And they're not discriminated.
Yeah, they're not discriminating against any sort of age barriers as well.
Exactly.
Statutory redundancy, okay? Redundancy pay, you'll normally be entitled to statutory redundancy pay if you're an employee and you've been working for your current employer for 2 years or more. You'll get half a week's pay for each full year you were under 22, 1 week's pay for each year you were 22 or older but under 41, 1.5 weeks for each full year you were 41 or older. Length of service is capped at 20 years. Your weekly pay is the average you earned per week over 12 weeks before the day you got the redundancy notice. Termination of employment contracts. So dismissal generally refers to the circumstances where an employer terminates the employment contract of an employee at usually the fault of the latter. Minimum notice, if a period of notice is not expressly agreed under the Employment Rights Act, imposes the following notice: 1 month to 2 years, 1 week period, 2 to 12 years, 1 week per complete year, and 12 years plus 12 weeks period of notice. You are not entitled to statutory redundancy pay if you fall within one or more of the following categories: former registered dock workers, Crown servants, members of armed forces or police forces, apprentices who are not employees at the end of their training, and a domestic servant who is a member of the employee's immediate family. Short-term and temporary layoffs. You can claim statutory redundancy pay if you are eligible and you have been temporarily laid off for either more than 4 weeks in a row, more than 6 non-consecutive weeks in 13-week period. You need to write to your employer telling them you intend to claim statutory redundancy pay. They must be done within 4 weeks of your last non-working day in 4 or 6 week period. If your employer does not reject your claim within 7 days of receiving it, you write to the employer again, giving them notice, and your claim could be rejected if the normal work is likely to start within 4 weeks and continue to at least 13 weeks. Consultation. You're entitled to a consultation with your employer if you're being made redundant. This involves speaking to them about why you're being redundant, an alternative to redundancy. Now, some companies provide alternative within the company, alternative roles, and trying to keep you, they try to make one job redundant, but then you may be able to apply internally for other jobs.
Isn't it
If your
almost a
employer is making up
requirement
to
based?
19 redundancies,
Isn't
there
it
is a
almost
requirement
yeah.
under the law to
Yeah.
say that, you've got to not make a job available, but you've got to let them apply internally for jobs that are
Yes.
available.
Yep.
Length of consultation. So there's no time limit for how long the period of consultation should be, but the minimum is 20 to 1999 redundancies. The consultation must at least 30 days. 100 or more redundancies, the consultation is at least 45 days before any dismissals takes effect. Unfair, wrongful, and constructive dismissal. And that's the ACAS, Advisory Conciliation and Arbitration Service. The Advisory Conciliation aims to improve organisations or working life conditions through better employment relations, working with employers and employees to solve problems. And they go to an employment tribunal. Before they go to an employment tribunal, they try to do mediation, okay? And that's trying to get, the matter resolved. ACAS Code of Practices: employers and employees should act consistently. Employers should carry out any necessary investigations to establish the facts of the case. Employers should inform employees of the basis of the problem and give them the opportunity to put their case in response before any decisions are made. Employers should allow employees to be accompanied at a formal disciplinary or grievance meeting, and employers should allow an employee to appeal against any formal decisions. Unfair dismissal. What could amount to unfair dismissal? Give me an example of where something may become unfair dismissal.
Maybe when employer doesn't know certain things or forgot, or maybe company is just big and someone made mistake. It was like not like on purpose made. That's one thing.
Okay.
I mean,
what else?
Because it happened.
Could a whistleblower be dismissed?
That's right.
Yeah.
Yep.
Someone who's whistleblowing about the company. So someone who's talking about the company. So your dismissal could be unfair if the employer does not have a good reason for dismissing you and is not following the correct formal disciplinary process. Situations when dismissal is likely to be include things like flexi working, resignation, refusal to give up working time, rights, for example, take rest breaks, maternity, paternity, adoption leave. Also, you know, a big one that's some companies don't like doing is giving people time off for jury service, but it's a requirement.
Mm-hmm. Yeah.
You know, you have to give, if they've been called to jury, have they requested it themselves, or is it just something that they've been sent?
Yeah, it's
When
sent
you want
usually.
to,
You can't request
you've
yourself,
been
exactly.
called for jury
Yeah, that's right.
service. It's not a request that you've put in, so you know it's unfair and you can't be dismissed on them purposes. But some companies I do know don't like allowing people to go on jury service. Constructive dismissal is when you are forced to leave your job against your will because of the employer's conduct. The reasons you leave the job must be serious. For example, they do not pay you or suddenly demote you for no reason, force you to accept unreasonable changes of work. For example, tell you to work night shifts when your contract is only for day. Let other employees harass or bully you. And that's a big one, harassing and bullying. Because that's one that is quite a big one, and people are taken to employment tribunals because of that.
Yeah,
Your employer's breach
time.
of contract may be one serious incident or series of incidents. You try and sort issues out by speaking to your employer before you go to a tribunal. If you do have a case for constructive tribunal, you leave the job immediately. Your employer may argue that by staying you accepted conduct or the treatment. So you need to be really, really careful when you know, there's been incidents of bullying or any sort of, you know, issues on harassing. Equal opportunities legislation. So the Equal Opportunity 2010, the Act, came into force in August 2011, and its primary objective was to encourage the identification of discrimination, victimization, sexual harassment, and to further implement them. So the characteristics that are protected are age, disability, gender reassignment, marriage or civil partnership, pregnancy, and race, religion, or belief. Why do you think these are protected characteristics within the Act?
Maybe because it's quite a popular case and there are many cases, and to prevent all of it, that people would still remember that there is this
Yes.
which is strong, so
They may be,
that they don't start.
and also, no, why else? Yeah, that's right. Why else do you think that these are very important characteristics?
Well, any act, any regulations, anything what is relevant to the law, it's important to have written black and white, so we know what is allowed and what is not allowed.
Yeah, but when you look at Equality Act, does it overlap with the Human Rights Act?
Well, I think none of the law or regulation is perfect. That's why it develops, and people developing and looking to get it better. Because if you are quite smart enough, you will be always able to find the law anywhere.
Yeah, but when we talk about the characteristics, why they are protected, we've got the Equality Act and we've got the Human Rights Act 1998, and they look at religion and they look at your sexual orientation. Is it because these are important characteristics within, you know, equality and diversity and, you know, equal opportunity and things like that? Sorry, what was that?
Absolutely. Yeah, diversity and inclusion is one of the main characteristics of DE&I, which is being very much talked about, is this.
Yeah.
And
do you think
some of
more...
it could be easily, kind of overlooked if it's not documented. That's another reason, right?
That's the thing I was saying, you know, things like religion, you know, the fact that if, for example, if you have Ramadan and if you have Eid, you know, they are required to give you a day off. There's not any sort of requirement like that, but, you know, you can request it. And your religious belief, you should be able to wear what you want. You know, if it's talking about someone who's quite religious in their Christianity, they wear a cross. There's been cases of big companies like British Airways that have been done for equal opportunities because there was a case called Smith and McCarthy, I remember years ago, and they didn't allow one of the air hostesses to wear a cross.
Yep.
And so, you know, based on things like that, your religious belief, your sexual orientation, your disability shouldn't be one of the things that should be taken into, you know, anyone shouldn't be victimized or discriminated on them basis. They are quite strong characteristics, and you know, a case, if you can prove that. I remember a while ago we had some harassment cases, and the woman was paid out £600,000 because she proved that she was being harassed and bullied.
Yeah,
So,
remember,
you know,
it's not just for the protection of the employer, it's you know, it protects employee as well. You know, that's kind of protection of the labor force.
Yeah.
So it has got, you
we
know,
need that protection though,
both
don't
ways.
we?
Yes.
I think, Najim, we need that protection as an individual as well.
Yep.
Yeah. So journals, some journals there, rediscovering process values in employee grievance procedures that you could look at, and the links are just there on there. So any sort of further reading you can do there. And these are some backup slides you can have a look at in your own time, which looks at, which I'll go through, which looks at the ACAS code of practice. So raise and deal with issues promptly, act consistently, carry out necessary investigations, give evidence an opportunity to put their case before any decisions are made, may be accompanied at formal meeting, and the right to appeal. Disciplinary, there to establish facts. Investigatory meeting you have investigate fully and collect evidence, so no disciplinary action at investigatory meeting. Suspension must be paid and short a time as possible. Disciplinary to inform, so ideally there's 3 days written notice, you give full details including copies of evidence, your safe dismissal is possible, and you have the right to be accompanied. So it could be a union rep, it could be a minute taker, it could be a fellow worker. The meeting you have your review your evidence, you prepare questions in advance in a confidential room so there's no interruptions. You're reminded of your right to be accompanied. You stay calm and adjourn before making a decision. Disciplinary, the decision making, so secret recordings. Is any disciplinary action warranted? Is there any sort of reasonable sanctions? You need to confirm that in writing. You need to state the reason and the improvement expected, so word it carefully. Set a time for review. If you fail to improve, remains current for limited time, and you have the right of appeal. Why is it important when we talk of a right of appeal? Why is it important to have a right of appeal in any circumstances?
Well, it could be dismissed information or facts which would change the decision. So it happens everywhere, and there are many cases. So when the information was dismissed or not provided on time, or somehow hidden, and someone was then, you know, finding the right information, there are many things which it just shows that we have rights to appeal.
Yeah, and it's important because there might be new information that you want to produce. So
Exactly.
you are able to, you have the right of appeal to challenge the decision. Gross misconduct, so immediate dismissal for first offence. Follow a fair disciplinary process. There's no notice. Notice pay will be due. The appeal process, so can appeal against any disciplinary action. You insist appeals are made in writing by a set time. It mirrors disciplinary process. The manager is not previously been involved, and you are informed of the outcome ASAP, and there's no further right of appeal. So you have that right of appeal. Grievances. So you establish the facts. They have a notice of formal hearing. You have the right to be accompanied, and you have a decision after the meeting. You inform them accordingly, and you have the right to appeal. Recommended actions: follow the ACAS for all disciplinary grievances. Suspend with pay while investigating gross misconduct. If you are unhappy with performance, act early. Dignity and responsibility. Take dignity front of mind. Take responsibility for ensuring dignity. Clarity, ensure you have been understood. Ensure that you understand. Responsibility, it's your responsibility to ensure that the employee understands what is happening and has a positive experience during the meeting, regardless of the outcome. The grievance meeting is not a confrontation, but in some cases it is, because some people feel like that, but it's extremely difficult to predict how the employee will react. Even the employee has openly expressed a desire to leave the company or talked openly about how little the situation bothers him or her, he may find the reality of the meeting distressing. You may find the employee's emotional reaction surprisingly and distressing. Employee or independent contractor, and the tests is control, integration, multiple, distinction, statutory protection, vicarious liability, the formation of a contract. So you have implied terms, which is duties of the employee, and then duties of the employer. And statutory provisions, you have the ERA 1996 and the Employment Act 2002. The termination of a contract, wrongful dismissal, so you have the definition and the remedies. Unfair dismissal, so permitted reason, inadmissible reasons and remedies, and then the redundancy, the definition and the compensation. The HR planner has to operate within the context of a range of laws that protect individuals and groups, and whose main aim is to ensure all employees are treated fairly. This covers the whole of the employee relationship, from sourcing staff to parting from them. In this topic, you consider the main areas of the employment law you need to be aware of. So fairness in recruitment. The HR planner has to consider a number of equity issues in recruitment and selection of employers. So unlawful discrimination. So the process, you know, it has to be fair, and the terms and conditions offered, including things like pay, pensions and benefits, on the grounds of sex, marital status, gender reassignment, sexual orientation, race, disability, religion, age, trade union membership or not trade union membership, status as fixed term or part-term. Basis of discrimination, we have direct discrimination, treating someone less favorably on the grounds of sex, race, and so on. Indirect discrimination, applying on apparently general rule, which is practice disadvantage one's sex or race. Harassment, violating someone's dignity or intimidating someone, you know, degrading someone. That happens, you know, sometimes managers do that. You know, they're quite offensive, they're intimidating, they're hostile, they make the person scared, which is harassment. Victimization, treating someone unfairly because, for example, they plan to raise a discrimination-related grievance. So these forms of discrimination still happen within the workplace. Fairness and protection during employment. An employee has a number of rights throughout their term of employment, which they need to be aware of. Here's a list of the resources you need to use to find out more. So it's unlawful to discriminate, as we mentioned. Health and safety is a big one. Why is because you as an employer have a duty of care to your employees, that they are not affected, or you know that everything falls within health and safety regulations. Why is that? Why do you think that's so important?
To protect the labor force and the company, either both ways.
Yeah. Yeah, it protects the individual and the company, because if you have a health and safety, you know, if you have a person who takes you into court for issues of health and safety, could it turn out to be a criminal case as well?
It could, exactly.
Yeah. So you've got to be really careful as a business or an organization that you protect employees and employers' rights.
Yep.
Under the Data Protection Act, the employer must comply with the principles to protect personal information. And under the Information Consultation of Employees Regulation, employers with 50 or more employees must provide written statements which specify the main terms and conditions of employment. Family-friendly law. Family-friendly law falls within a number of headings: maternity rights, adoption rights, parental leave, paternity leave, and pay, right to request. This has increased, this family-friendly law. Why do you think there's been a lot of changes in family-friendly law now? Especially on like adoption rights and parental leave. Why do you think there's been lots of changes?
I think some of it is organization do understand that the flexibility does not directly or correlated to the productivity. So, giving flexibility to the employee,
Yeah.
employee is happy, they will deliver more. There'll be better productivity.
Yeah.
That's one. Again,
And
second
also,
thing is obviously,
the issue, sorry, the also issue with adoption rights is more people are adopting.
yeah, exactly. So
they should be given the same rights as, maternity rights,
Yep.
parental leave, the father, maybe the breadwinner or it changes. So you've
Yeah.
got to look at, what people want to, they've been given more laws in place for these so that they have protection in place, and there's legislation in place that says you have protection from discrimination on grounds of pregnancy, antenatal care, statutory maternity, and also, if you discriminate on paternity leave, adoption rights, there will be case in itself. Again, we go to adoption rights, the next one, that you can't, discriminate on grounds of adoption. Parental leave is another one. So, has the right to take unpaid parental leave. Foster parents as well. They can take up to a total of 13 weeks parental leave. If the child is adopted, it's 13 weeks parental leave as well. Paternity leave and pay. A male employee can take statutory paternity leave for up to 2 weeks if they are an employee with a contract of employment. They are the biological father of the child or the mother's husband or partner. Have they been with the employer at least 26 weeks and will be fully involved in the child's upbringing. Emergency leave. Employers have the right to unpaid time off to deal with emergencies involving a dependent, a husband, wife, partner, parent, or anyone living in the household as a member of a family. Which Nazim, you talked about the request for flexible leave. They have, if you've worked with the employer for 26 weeks, you have the right to request, flexible working conditions. If you have a child under 16 or a disabled child under 18 who receives disability living allowance. Leaving the organization, an employee may leave employment of their own conduct or dismiss with or without notice, which means the contract of employment is terminated. An unfair dismissal is when the employee is dismissed and the employer doesn't have a valid reason for the dismissal or has acted unreasonably. Fair and unfair reasons for dismissal. So dismissal is potentially fair if it is on the grounds of misconduct, capability, redundancy, retirement, or legal restriction, and other reasons. So we finished this session on learning outcome 4, and we've looked a lot at data protection, employment law, and the conditions in regards to that. Has anyone got any questions before we finish off?
I have a question still regarding the assignment. Just to have a clear understanding, please, because I've missed the first weekend. So basically,
the assignment session is next week.
Oh yeah, of course. But just well, just to understand. So basically, all of those 4 sessions which already happened, we have like generally to collect all of this information, and regarding each of the session, we have to write how we understood it. Yeah, am I correct?
No. We haven't got the assignment yet. Okay, so when we've got the assignment, which is next week, I will show you the assignment, and then each assignment will apply. There may be parts of the assignment, I've not seen the assignment yet, parts of the assignment that might apply to learning outcome 1. There may be parts that apply to learning outcome 2. There may be parts that apply to learning outcome 3, and there may be parts that apply to learning outcome 4. Now, you will be told when you're doing the assignment, it will say next to it, learning outcome 1, learning outcome 2, learning outcome 3, learning outcome 4. It will tell you which part applies to which.
Okay, and then we need to write, and let's say this, like approximately 10 pages about this subject.
You need to, when we got the criteria, when I go through the assignment and we go through the criteria, it will identify what you need to do for each part.
Okay, I got it. Okay.
But you would need to be, you've done learning outcome 3 via LETA and learning outcome 4. 1 and 2 was done last week. So what you need to do is get them recordings and listen to them. What I might do at the start of next week's sessions, which will help some of you, is do a summary of all 4 learning outcomes before we go to that assignment. Is that okay with everyone?
Yep, that makes sense.
Yeah, so I'll summarize all the learning outcomes we've done, 1, 2, 3, and 4 up till today, and then we'll go through the assignment session.
Yep, sounds good.
And that will help you then understand. But all these are recorded, so you can get access to these on Moodle.
Yeah.
Thank you.
Okay?
Okay.
Any more questions?
No. Thank you so much.
Has anyone got any more questions?
It's Maksud. On the assignment side, so as far I can understand, that it has not been released yet. So it will be released next week. And
What's
what's
that?
The assignment.
Brown sugar.
The assignment, we do a discussion session like we do each week for learning outcome 1, 2, 3, and 4. I will do a session online with you, okay? About the assignment.
After the session, normally how long do we have to submit the
2
assignment?
weeks. Normally 2 weeks. But if you need extra time, you need to contact Raman.
Okay. No, that's fine. Yeah.
But it's normally 2 weeks, but we'll go through what the expectation is, what you need to do. If you want to achieve a pass, merit, and distinction, you have different criteria, and I'll go through all that with you next week.
That's fine. Thank you.
Other questions, anyone?
No, thank you.
Oh, all is fine. Thank you so much for your time.
Thank you for your patience, and I will see you next week.
you.
Have a nice week, everyone.
You too.
Thank
Bye
you.
bye.
Bye-bye.
I hope you get better, Hamish. Thank you.
Bye-bye.
Thank you. Thanks a lot. Have a good week. Bye.